Good afternoon, ladies and gentlemen. We're not going to have a ceremony as such to end this conference, but I'd like to just make a few closing remarks before, as tradition now has it, that I'll call on the stage the wonderful staff of the SG's chambers who put together this conference for us and publicly acknowledge them. Firstly, my apologies, I was not here yesterday. As the Prime Minister would have mentioned, that we had a very, very important conservation environment management conference in Suva over the past 5 days, which closed yesterday. And there had to be a very comprehensive undertaking and communique that had to be delivered at the end of the conference, where we had something like 600 delegates from around the Pacific region who attended this particular conference, setting the stage for the environment management of the Pacific for at least for the next 5 years, which Fiji is now chairing. The purpose of this conference, as you would have seen, obviously was a focus on the new constitution. But when we were actually planning for this conference, the idea was to engender discussions, not just at this forum, but also when you go outside this forum. There needs to be a lot of discussions in the public space regarding many of the issues that have been set out, addressed, indeed incorporated in the Fijian constitution for the first time ever. Things like socio-economic rights in a very comprehensive manner. There is absolutely, or one would say, hardly any jurisprudence in Fiji regarding socio-economic rights. As I mentioned to a group of accountants about 2 or 3 months ago, that in Fiji, unfortunately, we do not have a culture of having independent commentators as professionals giving their views in the public space regarding areas of public interest. It actually is lacking in a very, very, I think, tragic manner. So, to use the Australian elections as a recent example, when the two key political parties had put out their manifesto and had said what they were going to do in terms of policy, in terms of how much money they'll put in education or take out, etc., you had a lot of people who independently were saying this would mean an X% of deficit on government finances, or financially it would mean this, or legally it would have these sorts of ramifications. And the media, in fact, would go and seek out these professionals and get their views. And the public would actually listen to these people because they're giving their views as independent professionals. In Fiji, we do not have that culture. You never see an accountant before election saying, well, SODELPA, NFP, Labour, whoever, Green Party that may be, or any other PDP, or Prime Minister Benny Marama's party has said this, and it will have an implication on our deficit, or it will be 10% blowout of the budget deficit, or it will mean a 2%, or indeed we'll have a surplus budget. Nobody ever says that. Nor does the media go and seek out those kinds of opinions, not that I'm aware of. In a similar vein, we do not, for example, have lawyers giving independently their views or assessments in terms of the legal framework. There has been a lot of debate, for example, recently, and I know we are on the discussions, religion in a secular state. I do not recall any lawyer coming out, nor I do not know whether Fiji Times or Fiji Sun went out and sought the view of, say, for example, Mr. Chen Yang as to what he thought of Section 4, Section 22. What did it mean? Why did it have to take the AG's conference to vent out some of these issues? That's what we are trying to engender. And we hope that many of the issues that have been discussed today and yesterday would give you the confidence, would give you the ability, and would in fact provide food for thought that in the future, and in particular in the lead up to the elections for next year, that there will be these independent professional views being sought out. Unfortunately, the reality is that in Fiji, we are so beholden, or have been beholden, to whether it's ethnic politics, religious politics, whether it's provincialism, whether it's personalities. But we need to break out of that. Because it is critical, if we do want to modernize Fiji and want to become, everybody says we want to become like Singapore, hopefully we won't become like Singapore exactly, but if we do want to become like countries, liberal democracies, modern infrastructure, access to various socio-economic benefits, we need to also expand our horizons and be able to soak up these kind of debates and indeed hear them independently, and as professionals you need to provide that. So essentially that was one of the reasons as to why we had these sorts of discussions, and indeed invited many of the speakers who appeared before you on the stage, and I'd like to thank them for their participation. We in fact specifically invited these people for a particular reason, because you only get to hear them in the media, some of them you don't. So we sought their services, we sought their input to in fact engender that discussion and inculcate that idea that we can always talk about these issues without necessarily feeling inhibited. I'd like to just make some few comments. My staff have very diligently briefed me about some of the discussions that were held yesterday, and I sat in the session in the socio-economic rights towards the end, and of course the elections one. But I'd like to just touch upon some of those issues. The first, of course, was, and I know we talked about the civil and political rights. The only thing that I can say from that is, I think Davnesh Sharma had mentioned about the fact that the 1997 Constitution had a reference to the exceptions being interpreted through a democratic society, how it would apply in a democratic society. But of course we now in this Constitution have the test of necessity. And that in fact is the test that is applied through the Human Rights Commission, UN Human Rights Commission. In fact, we had correspondence with them on it. I think it's Ms. Pillay, who is the commissioner of the UN Human Rights Commission, and she wrote to us. And that's precisely the reason why we have in fact incorporated that in terms of the exceptions to the civil and political rights. And I think it is very important to note, as I think there's somebody who from Women's Crisis Center raised the issue about civil political rights vis-a-vis socio-economic rights. And as the Prime Minister mentioned yesterday, in Fiji we've actually applied both these rights at the same time. Some countries have taken this sort of linear approach that you can only have civil and political rights once you have socio-economic rights, or the other way around. But under this Constitution we have actually had both of them apply at the same time. But I think the comment that should be made is that in fact in Fiji, it's only been in the past few years that we've had a focus on socio-economic rights. And that focus on socio-economic rights is a very recent event. So we cannot say that civil and political rights have always been compromised, or have been over the past 10 years at least compromised, because of socio-economic rights. They haven't been. And I think the idea is to develop jurisprudence in both those areas. And as lawyers, we need to contribute towards that. And I was glad that there was some case law that had in fact been highlighted, Grootboom, etc. But also cases like Subramani from South Africa regarding access to health services. There is, as the Prime Minister mentioned, a case now before the courts regarding access to housing. And I think the TLTB, Ministry of, Housing Authority, and the government are named as the defendants in that case. And it will be very interesting, in fact we encourage that, to see how that would develop, in particular given many of the social policies that have been put in place. The issue about some of the ouster clauses that are in some of the decrees that had been put in place, of course, as the Constitution provides, that once the new parliament is elected, obviously it's a prerogative of that new parliament to get rid of any of the decrees that are currently in place. They can amend it, they can repeal it, they can build upon it, or they can just simply leave it. That's a prerogative of the new parliament. And that's only 9 or 10 months away, at the very best. So, but I'd like to make a side comment. If you look at many of the ouster clauses in terms of the non-challenges to some of the decrees that have been put in place, they're fundamentally related to predominantly civil type of issues. This property where we are on, which is owned by FNPF, was in fact, the company was owned by an undischarged bankrupt from Europe who had X percentage of shares. A number of other stakeholders. They were going to sink close to $900 million of FNPF funds, which is approximately a third of the asset base of FNPF, about $3.2 billion. A third would have gone into this property. Something radical had to be done. Of course, if that radical action had not been taken, and it would have been subject to various court challenges, and given the deficiencies in the laws at the time that these people became shareholders, would have still been languishing in the court system, perhaps. and this property would have never been developed, and FNPF probably would have lost $1 billion of your money and our savings. So these are some of the reasons why some of these ouster clauses, in fact, were put in terms of these decrees, and most of the decrees you'll see, in fact, related to those sorts of civil type matters, quasi-civil matters. AFL, we now have 2 of the properties in the departure area paying approximately $16 million in revenue as rent, concession. When this was set out many years ago, they were paying only about $3.5–4 million each. It's prime real estate, and they need to pay the right market rent. Matters were before the courts. Documents were presented, they were deemed to be fraudulently obtained. So these are some of the issues that in fact have been addressed in some of these decrees. The issue pertaining to, and I think probably related to that, obviously I'll just talk about the socio-economic rights, which is of great interest to us. As I said, there's not much in terms of jurisprudence in Fiji regarding socio-economic rights. But it is critically important, as the Prime Minister highlighted, many people would argue, is because of the lack of focus on socio-economic development in Fiji that has probably precipitated or led to many of the political upheavals we've had in Fiji. A sense of marginalization from the center. And indeed, this is where the media plays a very critical role, because in terms of the focus of the media tends to be those within the center as opposed to those outside on the margins. And this is where people need to be given a voice, and in terms of empowerment. This is why it is so important when we talk about civil and political rights, they should not simply be on paper. We need to have, for example, access to legal aid. It's great to talk about justice and equality for everybody, but if people cannot access that justice system, then it's no use to them. This is why you need access to legal aid. That's why it's constitutionally being provided for now. And next year, as you know, as the Prime Minister announced in 2014 budget, they've been given $4 million in setting up various legal aid commission offices all over Fiji. But I completely agree with Dr. Slatter's observations about the fact that socio-economic rights can, in fact, be fundamentally impinged upon by many of the multilateral agreements that are currently being looked at or have been signed, because it does take away various sovereign powers, in particular in the developing countries, that exists. And it further marginalizes people because the ability of the sovereign state to have some form of control over things like tariff rates, in terms of market access, it becomes very, very limited. A case in point, for example, is the Economic Partnership Agreement. I know our European friends are here, but it is a huge problem. Fiji perhaps is somewhat lucky, but in some of the other Pacific Island countries, the only resource they have is fish. And if an EPA allows the vast Spanish fleet of fishing boats to come in and scoop up all the migratory species of tuna and all the other sea resources, these countries will have nothing. 3 of those countries, I think, are also below 12 feet sea level. And I think the Prime Minister raised a very, very critical point yesterday at the closing of the Conservation Conference. A country like Tuvalu, which is highest peak above sea level, is 12 feet. Potentially in 20, 30 years' time, they may no longer be a Kiribati. What will happen to them? They've already bought 6,000 acres of land in Vanuatu. What will happen to issues like citizenship? There's a whole sovereign state disappearing underwater. It does have implications for us also. It has implications for dual citizenship. So these are some of the, I think, challenges that are being faced and that we also need to consider. They may not necessarily be directly related in terms of what is happening under the Constitution, but I think as lawyers, as professionals, as leaders, you all need to think about some of these issues that will affect Fiji. I think in respect of the socio-economic rights related to that, the question was raised about land ownership. Unprecedented protection for land ownership in Fiji. Section 29. There has never been an incorporation of protection of land ownership in any of the constitutions in the Bill of Rights. And if you read Section 6 of the Constitution, it does say that it applies to all arms of government, executive, legislature, judiciary, of course, and all other administrative decisions. It's unprecedented protection. Under the 1997 Constitution, whilst you had the so-called entrenched provisions, they weren't entrenched provisions per se, they were entrenching of specific laws. And if those laws had flaws, then obviously we're in a tight situation. In fact, that's precisely what happened in Momi. In fact, that's precisely what happened in Denarau, where you had e-tauke land being ultimately converted to freehold land, and that was the intention right from the beginning. Section 28 of the Constitution says you can't do that. You cannot convert e-tauke land to freehold land, period. And if you do convert e-tauke land for compensation to state land, if the state no longer requires that land for that particular purpose for which it originally acquired it for, it has to return that land back to the landowners. The philosophy behind that is that the current parcel of land holdings of the e-tauke people must not ever decrease. So if it's approximately 91% at the moment, it should never decrease. It of course can increase, but it should never decrease. And also, now under Section 29, you have the protection in terms of ensuring the landowners get a fair return. We do tend to focus sometimes in terms of, well, the protection of the tenants. But I can give you numerous examples. There's a parcel of land in Tavua at the moment, which was leased out for 999 years. It's an e-tauke parcel of land, and the people there are paying a rent of $2 a year. It's a fact. There's a school there that's paying 10 cents a year. On the other hand, whilst giving a fair return or recognizing the need to have a fair return, it does also at the same time provide protection for tenants, security of tenure, ensuring that the leases are done on a fair and equitable basis. Again, unprecedented, Section 30 is access to a fair share of royalties that it's got from the ground below 6 feet. Ownership still rests with the state, but the fair share of royalties must go to the landowners, whether it's freehold or whether it's e-tauke land. The idea behind all of this is that these are legal issues that need to be dealt in a legal manner, and they are now resolved. The idea is now to focus on the socio-economic development of the country. The idea is now to focus on growing the economy, with of course protection of civil and political rights, all of that being equal. I think when we talk about development, the media does play a very critical role, and that I think was discussed, and we've got various speakers. Of course, we had Ashwin Raj as chair, and Vijay speaking on that, and Sharon talking about the community need for community radio. But I think going forward, what is also critical is that, and we've seen it ourselves, in fact you can see it from the reporting of the conference over here that was held yesterday, and how it's been reported in today's papers. How Fiji Times, for example, has treated some of the subjects pertaining, say, to the secular religion and the secular state, and how they have omitted perhaps from the debate that has taken place and some of the comments that came from the floor. And I think that's quite marked, because I was in fact informed about who said what in terms of, so I could prepare for this cobbled thoughts that I put together. And that is quite marked. And I think when we talk about media freedom, expression, etc., just as we expect, for example, the state to be neutral, so should the media be neutral. That's the fundamental premise, because you then cannot hide behind the idea of having a free press. If you are partisan, and indeed some countries, some newspapers are partisan, you have to declare your interest. It's very simple. We had the head of Transparency International in Fiji in 2008, a Canadian lady at that time, and she actually said that. If the media organization has partisanship, it needs to declare it. Say, this is our particular view, run first page, tell everybody. So when we pick up the newspaper or listen to your radio or watch television, we know exactly where you're coming from. It's very, very simple. Recently in today, not today, but in recent times, you've had the issue of what's happening in UK. About the UK Parliament actually proposing a set of guidelines from the media, and there's a bit of hoo-ha about that going on. And various other jurisdictions are talking about it precisely for those sort of partisan type of positions that have taken place. And I think it is critically important for the media to understand that role. I hate using the word responsibility because somehow the other kind of means that you want to control them. But it's not exactly that. Of course, religion in a secular state, a lot of debate about that. You had some very holy people up on the stage, perhaps closer to God than most of us, and they presented their point of view. And I think what perhaps is, and I understand Mr. Chen Yang had clarified that, when you read Section 4 and you read Section 22, you need to put it in the entire context. Section 4 talks about the secular state. And if you read Section 4, which I'd love to do, Section 4 actually starts off by saying, subsection 1, religious liberty as recognized in the Bill of Rights is a founding principle of the state. Religious liberty is there. You are free to practice your religion. As Section 22 says, in private or in public. Religious belief is personal. It's not private, it's personal. It's personal to you. The reason why it's personal to you in Section 4.2 is because we are talking about the state being a neutral agent. Members of the judiciary are also of different religious faiths, persuasions. But when you appear before a judge, you do not expect that judge to make a ruling based on his or her religious conviction, or just because if I'm a Muslim, it doesn't mean if there's an accused who's before me is a Muslim, therefore I should give him a light sentence. If one is a Catholic and the defendant is a Catholic, it doesn't mean that you should treat them better than others, because you don't expect that from the judiciary. In the same way, that's precisely what this Section 4 is saying about the state. If my good friend Reverend James Bhagwan stands for elections next year and he becomes Minister for Education, we expect him to treat all the schools equally. That's simply what it's saying. It doesn't mean that he gives all the money to the Methodist schools. It doesn't mean that if he's got clients coming and seeing him, he only gives preference to them. It can apply to anybody. That's what Section 4 is saying. But he can practice his faith. You can go in and practice your faith at the National Stadium. You hire the National Stadium. You can have an open-air church service. You can have your Hindu service in a temple outside or in a park. And you can also pray in your house. And there's absolutely no state-sanctioned religion. Nobody's saying there can't be a religious belief if they believe the second coming is coming next week. We stop them from saying that. You can say that. I was asked in the constitution consultations in Nandi, when we were talking about the role of the church and indeed the hate speech. And Tala said to me, said, can I preach to my church members that homosexuality is wrong? I said, of course you can. That's your belief. You're preaching in your church. Can I say that those people who are homosexuals will burn in hell? Of course. I said, of course you can. That's your belief. Can I tell my people not to become homosexuals? I said, of course you can. But the moment you tell them, let's go bash up all the homosexuals, that's a problem. Or kill them. Or say that, let's put them in the back of the bus. So these are some of the issues, in fact, that's coming to the fore, and I raise them because I think they're very important issues for us to consider. Many of you, in fact, would have clients who would use this. As you know, that the Human Rights Commission has now been expanded to be the Human Rights and Anti-Discrimination Commission under the Constitution. And of course, that would apply to the state also. And the state needs to fix up its act. There are many practices, many would argue, that exist within the state system that we've inherited from the colonial times, post-87, post-2000, whatever it may be, that we need to fix up ourselves. And these, of course, include things like access to information, freedom of information, in terms of the accountability and transparency provisions that have been put in place, the commission that's been put in place. The other topic, of course, that was discussed was losing track. The elections, the last topic. As was highlighted in proportional representation, I think Raman Singh is here. Somewhere I saw him earlier today. If we had the proportional representation, probably in the last two elections, NFP would have had at least 5 or 6 people in parliament. They have not won a single seat for the past 2 or 3 elections. Notwithstanding the fact that I think in one election they received about 36% of the votes, or 20 or 25% of the votes. So at least he would be happy with that. And I think that is the whole, the basis. Proportional representation is a philosophical approach. That's why it was taken on board. To answer Vijay's comments, we have at the moment, as we speak, about 5 experts from Australia and New Zealand, and the EU. We'd like to publicly acknowledge them for the input, the Australia, New Zealand, the countries, and of course the EU, for the input. They've been most generous in their support. We have, for example, at the moment, a lady from Australia who's focusing purely on human resources in the Elections Office. For those of you who may not know, the Elections Office, always after election, has been raped and pillaged. Everybody comes along from the civil service, takes away all the computers, takes away all the vehicles, takes away all the laptops, the staff all disappear, they go back to the different ministries. You're probably left with the skeleton staff. And then we wait for the next elections. And come the next elections, maybe a few months later, you've got a mate in the public service who wants to take some time off from civil service, take some time off there, and you hire him in the Elections Office. That's generally the trend. That's how it's been happening. The approach we have now, and she's developing that not just in terms of the structure of the HR structure, but also we want to develop specific career paths in the Elections Office. We want people to become specialists in the area of expertise within the Elections Office. We would like to have the Elections Office independent of the PSC. Only then can the Electoral Commission become truly independent, as was highlighted, Bilori. It's very, very important. So these are some of the works that actually are going on in the background. We actually do have a draft of a set of electoral rules that has been put together by a Canadian lady who is from the EU, funded by the EU. And the Vanessa Chang's team is looking at that at the moment in our drafting section. And we'll, of course, be talking to the other experts in terms of the input and to finalize that. It is critical from our perspective that for the next elections, it is held in one day. We do actually have counting carried out wherever the votes are cast. For those of you who may not know, but in Fiji always, there are only 3 places where we counted votes. Lambasa College, Natadola High School, Suva Grammar School, never in Marist. But anyway, those 3 schools were always where the voting took place. So if somebody voted in Yasawa Irara, then the ballot boxes would come all the way by boat, all the way to Natambua. If somebody voted in the interior part of Naitasiri, it would travel by vehicle all the way to Suva Grammar School. We don't know what happens along the way. And indeed, the EU report highlighted that for the 2006 elections. But the other idea, of course, of having the votes counted wherever they are cast is that it's a process of actual democratization. Because the people in Yasawa has never seen the ballot boxes open. They never see how it functions, how it works. They can all stand around and look through the windows or in the schoolroom wherever the votes will be counted. They can see how the entire system works. So it builds confidence into the system. And that is very, very critical. And that is, in fact, one of the areas that we have highlighted to them. And indeed, the appointment of people to the Elections Office need to be done in an open, transparent, and merit-based basis. For the electronic voter registration, when we said that these are the criteria one must meet to be able to be appointed a registration clerk, 70% of the clerks who were hired were women. We did not have a quota system. We had the entire system based on merit and people who were able to tick the boxes. And that's precisely what we intend to do for the hiring of the staff in the Elections Office. And they, of course, need to be apolitical. Just as the state needs to be apolitical, just the judiciary needs to be apolitical, so do the people in the Elections Office. Some of the discussions we've had, Father, the ballot paper, we don't want it to be very big. And one of the options that you had where you walk into the polling booth, you can actually see the ballot, the list of candidates, and you can simply choose whoever you want. And we're looking at ways of simplifying that. And of course, in terms of the residue of the votes, that's also been looked at. There are various jurisdictions. You know, Finland has a very good system also, and we are working at that, and hopefully that'll be finalized very soon. There'll be, of course, massive voter education. And that needs to happen. The voter education will obviously commence once all the rules are in place. And indeed, the political parties will also be invited for the education process. Because we do not want political parties to simply send the scrutineers the day before and we get a list of the names. We need to know beforehand. So they can also be trained. So they also know how the system works. So they also know what to observe and what to look for when the votes are being counted. So this is very, very important. And we're actually starting right from scratch. A lot of the work has been done, and we hope to complete that very, very soon. So it does sort of baffle us sometimes when we hear various political parties making statements saying that the electoral commissioners have not been appointed, supervising elections have not been appointed, therefore it cannot take place. Yes, of course it can take place. The logistics of organizing elections, we've got a lot of experts with us. If you're, I was told once when I was training to be a lawyer that if you spend 80% of your time thinking about what you're going to write, you spend the balance of the 20% writing it. In the same way, for planning for the elections, if you have a good plan, the logistics work out very, very quickly. We hope to have at least about 2,800 polling stations. There are some of the figures that have been thrown around, from that number to 3,000 polling stations. Ladies and gentlemen, that's just some of the comments that I have in respect of that. I'd like to highlight a point, though, and clarify an issue. The talk about privatization or divestment of government shares, or indeed reduction of tax incentives, does not in any way derogate from the state's ability to fulfill those obligations as far as socio-economic rights are concerned. In fact, as you can see that from the corporate taxes that have been reduced, and personal income tax, which most of you have benefited from, that have been reduced, tax collection in fact has increased, because less people are actually chorrowing now, so to speak. When the tax rate was 33%, some supermarkets actually have 2 cash registers, one for FERCA, one for themselves. Companies employed accountants to in fact and pay them large amounts of money to evade tax. And if you pick up any basic textbook, as far as revenue collection is concerned, the countries that have lower tax rates, in fact, have a greater chance of collecting all the revenue. And that's the model that we have gone for under the Bainimarama government, and it's actually working out quite well. I'd like to thank, ladies and gentlemen, everybody for their participation here this morning. By all accounts, people have said it's been very, very useful for them. And we hope, please, I urge you, if one thing if you can take from this, I urge you as professionals to be able to speak out your mind, be rational about your comments. Rationality does not necessarily mean you can't have an opinion. You, of course, have your opinion. But we need to encourage debate in the public space, just as we need to encourage the media to be able to focus on areas that are important to Fiji and bring those within the margins into the center. That's very, very critical. I would like to thank in particular the Australian High Commission for facilitating, as has been highlighted, some of the airfares of some of our speakers who have come from Australia. Glenn, thank you very much for that. Most appreciated. Next time we'll ask you to pay for the accommodation costs also. But thank you for that, and I'd like to thank the speakers for being so willing to come, and in fact some of them at very, very short notice. I'd like to thank all the other local speakers also who have come to this conference. We look forward to your further engaging with you. We have, before I forget, we have, for example, at the moment a UN team that's carrying out an assessment of the parliamentary needs that we will require. Of course, technology has changed. Our focus is that we need Parliament to be a lot more accountable because, there is this notion that once parliamentarians are elected, they kind of disappear. But the committee system, if many of you who would know the history of the Family Law Act, I think the parliamentary committee is set for about 2 years to finalize that. And indeed, there were, if you get paid a basic salary about $21,000 a backbencher, and if you get $200 sitting allowance a day for sitting in the committee, guess what you're going to do? You'll have a lot of committee meetings. And the passage of laws will in fact be be languishing within the system. So the idea is to fix up Parliament in itself in terms of reporting systems, in terms of media access, We would like the idea of parliamentarians, for example, having screens on their desks wherever they sit in Parliament, so when a minister or somebody else is presenting a bill, that all the information can be up there on the screens. They know exactly what they're talking about. If they're introducing a new bill, what are the effects of it, what's the impact of it. If you're talking about the environment, you can see all the pictures, etc. So these are the sort of things we're looking at that, and we thank the UN for providing the service. They're doing that for us, FOC, and they'll help us also to plan for the new Parliament. I'd like to, ladies and gentlemen, as we've done now, to call the firstly, the staff who have been pivotal in organizing this conference. You'll note when they all come up, and as I'll call all the other professional staff subsequently, they actually make me feel old because most of them are very, very young. The Aegis Chambers is very, very young, and they have done a fantastic job. In particular, many of them have been involved with the drafting of the Constitution, indeed the translation. Salaseni was quite pivotal in translating Choeli too. And it is not an easy task. In particular, when you do the translations from English to Itauke, we had used the USP to do the translations into Hindi. And as the Prime Minister announced, we're looking at other ways of making it more accessible to other Fijians. If I could call very quickly, and I think Mary's got some gifts for me. Green, Ropate Green, please come up. Sala, Laite, Robinen, Sofina, John and Choeli, please come up. This is your chance to do the catwalk. Eli, Sulueti, Lavinia, Yasmin, Rina, Una, Deepak, Neil, Avnil, Matai, Sefa, Ronald, Tebita, Thomas, Deepak, Alvin, Joe, Shelvin, and Nemani. Ladies and gentlemen, all these people who are coming up on the stage were directly involved in the organizing of this conference. They range from the professional staff to drivers and everybody else. It's not very easy organizing such a large conference at such a short notice. Please put your hands together for all of them, ladies and gentlemen.